The Honorable Judge H. William White, presiding. All persons having business before the court come to order. All rise, please.
Me or you?
You the judge?
Okay. We're calling the case, this is the case of Sean Wright versus Play and Learn Children Child Care Center. Are the attorneys for the plaintiff and your witnesses, are you present and ready to go?
Yes, Your Honor.
Okay. And are the attorneys for the defense and your witnesses present and ready to go?
Yes, Your Honor.
Let the record show that all the parties are present and the court's ready to proceed. Go and swear the jury, please.
Members of the jury, please stand and raise your right hands. Members, do you swear to serve as a juror in this trial to the best of your ability, honesty, and conscientiously?
I do.
Please be seated.
The trial judge is required to do a preliminary charge, and of course, that's what I'm doing. I'm Judge White. I am a judge in Venango County, although I now have what's called senior status. I've been a judge for 31 years, and for the last 10 years, I've been a senior judge. Senior judge is a good gig because I only work when I want to, and they call me and say, will you take this case or that case or this assignment? And because of that, I actually get pretty exotic cases and very interesting cases. So I'm in almost all the northwestern counties of Pennsylvania, including Venango. Last week it was Clarion and Crawford, but I do get around. So I really enjoy judging, and I have to commend the class, although I'm not sure. I guess talking with Ms. Grove, I'm not sure I should commend you, but you picked a really tough set of facts. This case is hard. I have 3 or 4 hours myself reading it, and there are a lot of nuances and complexities in this case, and it's great fodder for a highly skilled, experienced lawyer. So we'll see how you fellas do, but it should be an interesting case to try. Now, for the jurors, as you know, there are 2 types of jury trials in the United States. We have criminal jury trials and civil jury trials. Criminal jury trials where the prosecutor, usually the district attorney, has brought a criminal prosecution, and it will be the jury's decision to decide whether the defendant is guilty or innocent. In a civil proceeding, the jury is to decide the case based upon who should prevail based upon the law as the judge gives it to you. The civil proceeding, if you think back to the old days in feudal times when might was right, and if people had a dispute, they would duke it out or fight it out with swords. But in the modern era, of course, especially in the United States, where we have a highly sophisticated court system, people are entitled, as a matter of right, to have their disputes resolved by a jury of their peers. And hence, the civil case is a case where a private citizen, as often as not, is brought a lawsuit against another private citizen. Sometimes these are corporations, but they're nevertheless citizens. And the jury has to do justice to the parties as best they can. So it will be your duty to apply the law on the case as I give it to you, but it will be your responsibility to find the facts and decide where the evidence lies. The judge's role in a trial is kind of like a referee in a basketball or a football game. I'm to make sure both sides apply the rules and make sure that all parties get a fair trial. But I have no interest in the outcome of the case, and therefore please don't be influenced by my behavior. The jurors are the ultimate deciders in the case, and in my opinion, in our court system, they are truly the heroes of the system, because without their objectivity and without their hard work, the system would not have credibility. Now, this case involves the concept of negligence. And negligence is pretty easy to think about if you recognize that it involves the issue, does a person have a duty to do something or refrain from doing something? And if the breach of that duty brings about harm, then of course the person who had the duty to refrain from doing something or doing something is responsible for the harm and therefore is required to compensate the victim. Best example of this is, we all know the rules of the road. You drive on a highway and you are required, as you drive on the highway, to obey the rules of the road. But if you come to a stop sign and you don't stop and you go through it, of course, if nobody's there, you've broken the law, but there's no harm, no foul in that sense. However, if you go through a stop sign and there's a vehicle there and you hit it, then clearly you violated your duty. You're clearly negligent because it's a statute, and of course, the person who you hit in the other car is entitled to be compensated for their losses caused by the collision. Now, that's a very simple example of negligence. This case is a little more subtle, a little more complicated, but it is still the same general principle. So you'll be looking for the following elements. Does the defendant owe a duty to the plaintiff? Was there a breach of that duty? Did the breach itself cause injuries to the plaintiff? And what, if any, damages did the plaintiff suffer? Now, in this case, we have a child who's under 8. And here the law is a little different from Pennsylvania, but it is the law in our jurisdiction where we're trying this case. And that is that when a child is 8 years or younger under everybody's law, that child is presumed to be free from negligence. The child cannot commit a negligent act until they're age 8. However, in the District of Columbia, where this case is being tried, apparently it's the law, and I charge you it is the law, that the parent's negligence may be imputed to the child, and therefore the parents stand in the same footing as the child, and the child stands in the same footing as the parents, which means if there's negligence by the parents, then the child is equally negligent. And so you will keep that in mind because this case will involve those issues. This case will involve comparative negligence, and that's pretty much the law in every state now. Comparative negligence is where you decide, first of all, was the defendant negligent? Did he cause injuries? And then if you find the defendant was negligent and caused injuries, then you have to assess whether the plaintiff was negligent in a comparative way. And if the plaintiff was negligent in a comparative way, did that negligence contribute to the injuries? Ultimately, then you have to balance the negligence. If you find negligence on both parties, awarding 100% of the negligence, some ratio for the plaintiff, some ratio for the defendant, and that will ultimately reduce the plaintiff's award. Now, one thing you're dealing with in this case are fairly vast stipulations. Stipulations take two forms, and I see them in court quite a bit. We think of stipulations as time savers. They're intended to save time in the courtroom. These are issues that are not contested, and when the parties stipulate, then you as triers of fact are expected to accept the stipulation as fact. So one form of stipulation is where perhaps a witness can't be there, but the attorneys agree the witness may give a statement, and then you can accept the statement as testimony. That's a stipulation of testimony. You may or may not have that in this case, but you're certainly going to have stipulations otherwise, and a stipulation means the parties agree it is not a contested fact, and so you could not find in the course of the case anything different from what the stipulation recites. So a stipulation is a time saver, and it's intended to, in essence, have the parties agree upon facts that don't have to be tried. Credibility is the key responsibility of jurors. It's where the rubber meets the road in a trial. And credibility is actually harder to decide than you may think. The nice thing about credibility, it is ultimately a common sense issue, and each one of you in your everyday lives deals on assessing credibility in almost everything you do, and the system counts on you to exercise your common sense and your judgment in assessing credibility. So you will be required to assess credibility. The plaintiff has the burden of proof in this case initially to show that the defendant was negligent, that the negligence was causal, and that in fact there were damages, and that burden of proof is by preponderance of the evidence. Now the defendant also would have the burden of proof showing comparative negligence. So when we get to the part of the case where the defendant is contending that the defendant is contending that the plaintiff was contributorily negligent, then under those circumstances the defendant has the burden of proof. Now, unlike in a criminal case where the burden of proof is by legal and competent evidence beyond a reasonable doubt, which is an extremely high burden, in a civil case the burden of proof is by preponderance of the evidence. And if you imagine, say, a set of balance scales, and all the evidence is put on that, and all the evidence is put on that, and they're perfectly equal, then the plaintiff has not met their burden. On the other hand, if the scales tip ever so slightly, in favor of the plaintiff, then the plaintiff has met his or her burden. However, if the scales are even, or perhaps that way, then the party has not met their burden. So the burden of proof in a civil case is by what we call simple preponderance of the evidence. It's a much, much lower burden than in a criminal case. So again, you'll be asked a question, was there negligence that caused the injury to the plaintiff? Was the plaintiff negligent? Was it negligent? And the amount of damages. Now, in this case, singularly, the damages are stipulated to, and they are stipulated to at $115,000. However, the plaintiff is also seeking, is asking for $50,000 of what's called pain and suffering. That's a little more amorphous in what it is, but it's a very palpable claim. So you'll also be asked to assess whether or not there is pain and suffering. Now, we will proceed from my preliminary charge to the opening statements of counsel. I would encourage you to think of counsel's opening statement as something like, say, a table of contents to a book or perhaps a roadmap. In their opening statements, they're going to explain to you how they're going to go about proving their case and what their case is about. And then you'll hear, first of all, from the plaintiff, who has the burden of proof, and then you'll hear from the defendant. And it's not evidence, but it is important because it explains for you how they're going to go about proving their case and what the case is about. Plaintiff's counsel ready?
Yes, Your Honor.
Okay. And you can go ahead. Would you state your name for me, because I didn't get it?
Okay, my name's Owen Finch.
Didn't hear.
Owen Finch.
Thank you.
I'd like to call witness.
Okay, you're not going to do an opening statement?
Oh, that's what. My bad.
Ladies and gentlemen of the jury, I will be very straightforward. We're going to ask you to find Play and Learn Child Center guilty of negligence. Our first witness will be the mother of Junior, who says her son should have obviously been watched and suffered an injury because he wasn't. Our second is Tyler Larson, who is our expert testimony in childhood psychology. He will prove that the kid didn't have HIV, and it wouldn't be fair to use that against him. And lastly, we will have Lee Morrison tell us how Play and Learn is not safe. It's always been an unstable environment. Thank you.
Defense may open now if you want.
Ladies and gentlemen, I'm Josh Nettles, and these are my colleagues Alexis Bliss and Catherine Nelson, and we're the attorneys for the defense team in the case of Sean Wright versus Play and Learn Child Care Center. The facts of the case are Sean Wright enrolled her son, Junior, at Play and Learn Child Care Center. Junior is a highly active child and has been diagnosed with hyperactive impulsive disorder. Sean failed to inform Play and Learn Child Care Center of Junior's behavioral problems and refused to take him for further testing. Sean knew full well that Junior had behavioral problems, but made the decision, despite his knowledge of Junior's issues, to not notify the center of these conditions. Play and Learn Child Care Center did not take the necessary actions to cater to Junior's special needs because they did not know of his condition. Junior was placed in the giraffe room at the Child Care Center, and during snack on July 28th, Junior rose from his seat and climbed the changing table in the back of the room. Junior fell off the table and broke his arm. Preponderance of evidence shows Play and Learn Child Care Center was not able to take the necessary precautions to stop this from happening because they were unaware of Junior's behavioral issues. Providing testimony to these statements for the defense are Sidney Little, the director of Play and Learn Child Care Center, Dr. Ellis Baldwin, the doctor who diagnosed Junior with hyperactive impulsive disorder, and Dell Anderson, a neighbor who babysat Junior several times. Today we're asking you to use your best judgment to decide whether or not it was Sean Wright's fault that her child was injured after she lied to the Child Care Center and restricted them from providing the care her child needs, or Play and Learn Child Care Center's negligence to provide special attention to a child's needs they were unaware of. Thank you.
Go ahead, plaintiff, call your first witness.
I would like to call witness Sean Wright to the stand.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this case under penalty of perjury? Please be seated.
Ms. Wright, will you please state your name and role to the trial?
My name is Sean Wright, and I am Junior's mother.
How is it that you have a African child?
My spouse is black.
How are the issues with Mark and Junior similar in the education?
Well, both of my children have been placed with educators that haven't let them thrive, and I believe that's because their younger black males interrelate with them.
How old did you say your child was?
Junior's 3.
Only 3. What were you told by the Play and Child Burn Center to do for Junior to advance him in his learning and social skills?
I was told that he would be open to a healthy and a very student-based learning.
And how has Junior's injury affected your family?
I've been staying a serious toll on my family between his doctor's appointments, his physical therapy appointments, and his checkups. It's hard to handle it between work and 2 kids, and I feel like I haven't got to spend time with both of my kids. So
Do you have another spouse as of right now?
Objection.
She already
Ah.
answered. She answered.
Wait, he's allowed to state his objection, then you'll get a chance.
Leading
You should
witness.
stand when you object. It gets my attention,
Relevant.
okay? And your position?
She's a single parent. She's going for pain and suffering. That's relevant to the case.
Okay, but how is the fact she is or is not remarried material to that?
Because she's a single parent that works and doesn't have enough time to deal with all the injuries that was caused by the Play and Child Burn Center.
I like that argument. Overruled. Go ahead.
That's it.
No, she didn't answer your question. I don't think.
oh
Yes, she
no,
does.
I said no. I don't.
Okay.
She's not remarried.
No.
No.
Okay. Are you done?
Yeah, thank you.
Okay. Then say, pass the witness.
Oh, okay.
Or your
I
witness.
I passed the witness.
Okay, a lot of guys will just, your witness. Go ahead. No, hold it. You're subject to cross-examination. Let's try. That's the first one to try. You're running out of time. Is anybody going to cross?
Yes, sir.
I say the cross-examination is the most cerebral thing a lawyer can do. So it takes a lot of instinct and smarts. Go ahead.
Did you inform Plan about Junior's issue?
No.
Why not?
Well, I believe, since I know the background on young black males, I didn't believe that he was properly diagnosed with HIV.
And being as Junior is a child, do you feel you'd be hesitant to accept his condition if your father was?
If it was under different circumstances, I would say yes. But like I said, since I know the background on young black males being misdiagnosed with HIV, it's more of a fear of him being misdiagnosed, not how others see him.
No further questions.
Okay. Thank you. You may step down. Thank you for your testimony.
Yeah, I'm not ready.
Your next witness, please, plaintiff.
We would like to call Tyler Larson to the stand.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this case under penalty of perjury? Please be seated.
Tyler Larson, please state your name.
Can I
and
interrupt for just one thing? It's, everything in the trial is meant for the jurors. Everything is meant for the jurors. So even though he's the one talking to you, instinctively, you respond to him, but in fact, you should be responding to the jurors. And so it's hard to do. It's hard, and it happens all the time in court. But do your best to talk to the jurors and not talk to him, even though he's the one asking questions. I go through this probably once a day in court, this instruction. Go ahead.
Please state your name and role to the trial.
Dr. Tyler Larson.
Okay. What is your occupation?
I am a psychologist, and I work with early child development. I teach courses on it.
Okay. Where did you receive your education and training?
University of DC in Washington, George Washington University.
Okay. Have you ever published any articles or books?
Yes, I actually have 4 books on the hyperactivity and overdiagnosis in black males, one including active while black.
Okay. What professional license do you have?
I have a doctorate in the field of psychology.
Your Honor, I asked that Tyler Larson be admitted as an expert witness.
Do you have a position on that, or do you want to inquire?
No, Your Honor.
Okay, under the definition of expert, she meets the qualifications of an expert, and she's being received as an expert in the field of early childhood psychology. Please go ahead.
Tyler Larson, when a child is black, are they more likely to be misdiagnosed?
Yes. I've done multiple studies on this and have been part of multiple foundations that show that children who are black have 30% more of a chance of being misdiagnosed and having their parents being told by schools that they have HIV or related disorders.
As we know, Junior only has one parent. How would having one parent affect his behavior?
Well, not only just having one parent, we know that Junior's one parent had actually passed away. So the stress that causes, even at a 3-year-old's age, that can be detrimental to their behavior issues.
In your professional opinion, does Junior have HIV?
No, I do not believe that Junior has HIV.
Thank you. That's all, Your Honor.
Okay, you should say, I'm going to pass the witness, or you're a witness.
Oh, I'll pass the witness.
So, you mentioned something about how you did a study on Junior being black. And you spent a lot of time with him. How much time?
I spent a few sessions with Junior personally.
Okay, and would you agree that as the mother of, as Sean Wright being the mother, that she has bias on whether he would have HIV or not?
In my professional opinion, I feel that your parent is with you the most and may know when your child needs to be put through more appointments.
Okay, so were you paid to be here?
Yes.
Okay, and how do you think that affects, like, for them to pay you to come here and say what you're saying?
I feel that they paid me to be here to take time off of work so I could help with their child, but I don't believe that sways my beliefs or changes my bias towards this case.
No further questions.
Thank you. Okay, your testimony is concluded. Thank you.
I'd like to call witness Lee Morrison to the stand.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this case, under penalty of perjury? Please be seated.
To the jurors, I can't tell whether you're hearing it well or not, but because you have to decide it, you're very much part of the proceedings. If you're not hearing it, interrupt us, raise your hand, or get my attention. I'll have the witness speak up. But it is very important to me that you hear it, so don't be shy about that. All right, go ahead, please.
Please state your name and relation.
My name is Lee Morrison. I'm a former employee of Clayton's.
What was your job title when you what was your job title at the Clayton Center?
I was an assistant teacher.
It says here that you were fired from Landler. Why were you fired?
They said that it was because I couldn't get along with others, but I'm pretty sure that they just fired me because I didn't agree with what they did.
You stated that you did not like to work in the child care center's environment. Why was that?
Very unstructured. There weren't any really training programs. They kind of just let the kids just kind of roam around and play, and really didn't focus on the learning aspect.
How many staff members were in the room today of the incident?
We were understaffed that day because of the pink eye incident, but it was me, the lead teacher, and another teacher, but she stepped out during the accident.
Okay. What kind of behavior did Junior show that you would consider from the other kids?
Nothing really in particular. He's usually normal, happy. He doesn't play along with others, but that's kind of what 3-year-olds do. It's called independent play.
Okay. Thank you. Pass the witness.
You said in your witness statement that sometimes things can get chaotic when you're trying to keep 15 or 16 3-year-olds together and seated while you can serve them a snack, and that it's not the teacher's fault. So why? So would you say that it was because of they were understaffed that Junior managed to get on top of the changing table, or because it's chaotic because they're 3-year-olds?
Well, we're supposed to have 2 assistant teachers and a lead teacher, and then they have 1 assistant teacher and 1 lead teacher.
Play and Learn Child Care Center, their emergency plan is that the teacher can step out if there's an emergency in another room. So would you say that because they followed the procedures, that was what caused it?
Objection, first-hand knowledge.
Didn't hear you.
Objection, first-hand knowledge.
Do you have an argument against that, or should I sustain it?
He was in the room when it happened, so he was firsthand there.
Overruled?
Yeah, that's fine.
Nice try.
They didn't really follow procedures because it states that one person has to, it revolves around, so another teacher had to be in, but there was
So, but they did follow procedures because, like when Junior fell, they followed the emergency procedures. So obviously they did have some procedures. So would you say that it was them not following the procedures?
Objection, leading the witness.
Actually, he's allowed to lead.
Yes.
However, I think he's very close to the ultimate question. Would you like to make that objection?
No, you're good. Yeah.
Okay.
I was thinking we were somewhere else, but good.
All right, I'm treating the objection as withdrawn. So, go ahead, please.
So would you say that it was the breach of procedures that allowed Junior to get on top of the table?
Well, if they would have followed procedures and had another teacher step in when the other one stepped out, the accident probably would have happened in the first place.
So, sorry. But they did follow procedures because there was emergency in another room, so the teacher had to step out. It does not say that another teacher has to rotate in immediately. So they did follow the procedure there. So would you say that you were unaware of the procedures, or?
Yeah, I guess because they didn't really teach it.
No further questions, Your
Okay.
I would like to redirect the witness.
Okay, I think you're allowed, as I recall, 4 questions, is that right? 4, I think you're allowed 4 questions.
Okay. You said that you were already understaffed prior to the pink eye accident, correct? So that extra teacher leaving the room would also put you even more understaffed. Thank you.
That was only 2. Okay, thank you. You can sit down. Is this the plaintiff's last witness?
That is our last witness, yes.
All right, so the plaintiff, at this point, is the plaintiff rest?
Yes.
Plaintiff rest, and we're into the defense case. You may call witnesses.
Who's first? I would like to call Dal Anderson to the stand.
No, just how am I first? I am going.
We would like to call Dr. Ellis Baldwin to the stand.
Okay.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Please be seated.
Please state your name and position in the stand.
My name is Ellis Baldwin. I evaluated Junior Wright for hyperactive and impulsive disorders.
What do you do?
I'm a developmental pediatrician.
Where did you graduate from?
I graduated from Georgetown University and Howard Medical School.
What did you graduate with?
A BS in biology and behavioral sciences.
Where did you do your residency and medical fellowship?
I did my residency at Mercy Hospital and medical fellowship at Johns Hopkins Medical School in developmental pediatrics.
I would like to ask that Dr. Baldwin be qualified as an expert in the field of disaster.
Does the plaintiff have any objection?
No, Your Honor.
Okay, and again, he meets the criteria for an expert by virtue of his training and experience, and he is an expert in the field of developmental pediatrics. Go ahead.
What field do you specialize in?
Diagnosing and treating children with behavioral issues.
In the past 9 years, about how many children have you evaluated for HAD?
Over 800. In fact, the majority of my profession is evaluating children for these types of disabilities.
Have you tested child with HAD?
I have them, I evaluate them with multiple tests, and then I compare them with other children of the same age.
How did you review on these tests?
He lacked the self-control exhibited by the average 3-year-old. I gave him toys to play with, and he went through them very quickly and then threw them around the room.
And when you spend time with Junior, how does he act with you?
He was very fidgety.
Why did you suggest Junior seeing a teleconference?
For further evaluation.
Why did you feel Junior needed further evaluation?
Hyperactivity other than HID, for example, language impediment can cause hyperactivity. The standardized chart that is used to help diagnose HID requires that 7 of the qualities be observed in the child. I only observed 6 in Junior, but the 6 that I did observe were very profound, and I think that they were more than enough to diagnose him with HID, but because it was not perfectly conclusive, I recommended that another expert to use.
What condition, if any, do you feel Junior has?
It does not take a great deal of observation to see that Junior is hyperactive, and since the 6 qualities that I observed were very profound, I believe that he does have HID.
And how do parents react to you, to their child's diagnosis?
When parents come to see me, they don't just stop in to say hello. They have real concerns, and I don't believe that Sean was any different. Parents usually take a great deal of concern and action to make sure that their children get the help that they need.
Yeah, it's a high school.
Now, Mr. Baldwin, how much time did you spend?
Just a minute, counsel. He is the doctor. You should address him as doctor.
Okay. Dr. Baldwin, how much time did you spend with Junior?
About 2 hours.
About how long does it take to accurately diagnose a child with HID?
Junior's case was very profound, and he was very hyperactive. By the time the first hour had passed, it was very evident that he had some do believe strongly that it was HID, even though there's a possibility that it could be some other related disorder.
Okay, but still, you didn't technically spend enough time with him.
The amount of time spent would not have greatly changed the results. The results were just not perfectly conclusive to diagnose him with that particular disorder.
Now, within your witness statement, you said it was critical for HID, I believe it takes 4 months to observe it accurately. And you said it was critical for this. This isn't something you can just say you believed it was because he showed a lot of symptoms.
Yes, there is a lack of information for this disorder. It's being studied right now. There's not a whole lot of information for it, and so I recommended that he see another specialist in addition to myself to help confirm his case.
Okay. Did you have a written evaluation of Junior?
I did use the standardized chart to help diagnose him.
Your Honor, I asked that this test be Defense Exhibit A.
Okay, why don't you hand it to me, I'll mark it, okay?
Yes.
This is the evaluation?
Yes, it is.
All right, so you're marking it for identification as Exhibit A. What's the next thing you're going to do?
Your Honor, may I?
Well, the courtesy is show it to your opposing counsel first.
Okay.
And then show it to your opposing counsel. That's the courtesy. And then you can proceed to have him identified.
Thank you.
Mm-hmm.
Now, Dr. Baldwin, could you please identify what this test is?
That is to date, the most accurate chart believed in the profession to help diagnose children with HID.
Thank you. Now, could you please read this sentence?
A diagnosis of HID is
Make sure it's loud enough that they can hear it. You should get away from the jury needs to see him.
Okay.
All right, go ahead.
A diagnosis of HID is appropriate if 7 or more of the symptoms in the chart above, hyperactivity and impulsivity, have existed for at least 4 months according to a consistent observation by one teacher or child care provider who knows the child well.
Okay. Now, you said it takes 7 of these symptoms, right? In order to be accurately diagnosed with HID?
According to the standardized measurements.
Okay. Could you please tell me, before starting here, how many symptoms Junior shows?
He shows 6 symptoms, and the 6 that he shows are very profound, which is why I did diagnose him with HID, even though, according to the standardized chart, that is not quite enough.
This was prepared by a board of certified pediatricians. Are you going against their word?
Not all of the, each factor on that chart has a different severity, and as I said, Junior's, what I have observed in Junior, the 6 that he had were very profound. I don't go against what they said, but because they were profound and I have evaluated over 800 children for this type of disorder, I felt pretty strongly that he did have it.
Regardless of the severity of these symptoms, he only showed 6 of them, correct?
Like I said, this is an expanding field and widely unknown disorder, and so the chart by no means is going to be able to diagnose correctly every child.
Okay. I just found it odd how you went against the board of directors saying that they have to have 7 symptoms, but only 6 were shown. That is all I was getting at. No further questions, Your Honor.
Okay, thank you. Why don't I take the exhibit? Let's just leave it here so anybody who wants to use it can use it. Okay. Your next witness?
I'd like to call Sydney Little to the stands.
Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth in this case, under penalty of perjury. Please be seated.
Please state your name and how you relate to this case.
My name is Sydney Little, and I'm the Executive Director of Play and Learn Child Center.
And how many years have you been the director?
I've been the director for 10 years.
What was your first impression on Miss Wright?
Miss Wright, she seemed very anxious to get Junior into a new learning area, and she said that she wasn't satisfied with the school that he went to prior.
And what did you notice in Junior's behaviors?
I noticed, like, whenever we did the interview, we had books out, and then we had toys also. He didn't pay any attention to the books, and he just went rapidly toy to toy to toy.
And what have teachers reported to you that's been happening in their classroom?
Objection, hearsay.
Is it hearsay?
I mean, I guess because she's not in the classroom.
Say it again.
I mean, I guess because she's not in the classroom.
Okay. I'm going to sustain that objection.
You're wrong.
You need to withdraw the question, move on.
How many, if any, children at your school have you had with HIV?
We currently have one child with HIV. Yes, HIV. He's 4 years old, and he takes medication that works beautifully, so we haven't had any trouble.
And what do you do with him at the center?
So the way that we treat him is we have either a head teacher or an assistant teacher in the room with him, and they're specialized to work with him.
What type of training do you guys have at the school if an accident like this one happened?
We have manuals that say like what to do, any type of situation that we have, like fire drills, how to store everything. Whenever Junior got hurt, we even had like the teachers go to the hospital with him.
I'd like to pass it.
You are related to the Play and Learn Center, how do you say?
I'm the executive director at
And
Valley.
you have been for how long?
10 years.
Okay, what do you look like, or what do you look at in staff members that come into your center?
We look for people that are caring, patient.
Do they have to meet any credentials?
Yes.
What are those?
You have to meet credentials over like what we have, like whatever the Olympic board has.
Okay.
So like you have to have like a high school diploma. We require people to go to college, and you get a degree in child development.
Do you have the degrees or like the level of education they have to work at your center?
Well, you have to have education to work in my center.
What is that education?
So you have to go to college, I guess.
In the bylaws, chapter 3, okay, I'm not allowed to use this one.
Yes, but you probably need to mark it.
Mark it.
Yeah. You want to take, you can, yeah, you probably need to mark it. Yeah, let's mark that. You had A, did you?
No, that's
Okay, so we're going to call this 1, okay? And again, remember the courtesy letter. You're going to somebody's seen it. Okay?
your requirement for being a teacher.
Which ones was this?
Right here for your names and right here for your assistants.
It's been revised.
How?
He has the here.
Okay, chapter 3, section 315.4, teachers at the Child Development Center shall be qualified by meeting the requirements of the following. Number 1, a bachelor's degree in early childhood education related field with minimum of 15 hours of early childhood education courses. Number 2 is 2 or more years of college, including at least 15 hours of early childhood education courses and 1 year of experience in a child development facility. 3, a high school diploma or its equivalent and 3 years of experience as an assistant teacher plus 9 college credit hours in early childhood education. 4, experience as a teacher or assistant teacher in a licensed child development center provided that he or she has been awarded a child development associate credential. 2 of those you did not mention.
Yeah, I'm sorry.
been sued in previous cases?
No, never. We've never had anything like this happen before. We've had no trouble.
In your witness statement, let's see if I can find it here.
It says that I've never had anything happen like this. You seem a little underprepared.
Not that funny.
All right, there should be a question, and you should not answer unless there's the question. It's all right, it's okay.
Okay. Have your teachers tried to ever help Junior, and if they have, how?
In what type of situation?
You said he has HIV. You guys all think that, so how have they helped him to like look at him to make sure he doesn't hurt himself?
So we didn't know that he had HIV. We never would have said. His parents never came to us and told us that he had
Has there ever
HIV.
been- what was your reaction to, what were your feelings towards Junior? How did you express yourself towards him? How did the other teachers express themselves?
I'd be
Objection.
hearsay.
Hearsay.
Is it hearsay?
Yeah. That's-
Well, technically, and you're right, for what it's worth, in a normal trial, hearsay is admissible unless somebody objects. If somebody objects, then of course it's not admissible. So, but he did object, and there's nothing wrong with trying hearsay. All right, but the objection's sustained. Go ahead, please.
All right. Were you fully staffed the day of the incident?
No, we were understaffed.
Were there any other issues going on in the Child Development Center?
We had a pink eye.
So there was a lot of attention on that as well,
No,
correct?
they were all sent home.
Okay. Do you feel that if you knew that you had HIV that wasn't properly diagnosed, it would help?
Yes, because we take precautions whenever we find out children have special needs. We make sure that we have extra teachers in the room to assist them. Like we could have had Junior sit closer to a teacher to monitor, like to look at him more and make sure everything's going okay with him.
Were you present the day of Junior's injury? in the
Yes.
room?
I wasn't in the room though. I was there.
Okay. Good. Alright, did you attempt to find out yourself and how?
Yes, I asked the teachers that were in the room what happened.
Okay, did you get any information from them?
Yes,
What was it?
they told me what happened.
What did they tell you happened?
That they were doing snack time. Junior must have got out of his seat. They set the crackers down onto the changing table.
The teacher sat the crackers down onto the table?
Onto the changing table, yes. Because
Thank
they,
you.
Do you have redirect?
No.
No.
You do not have redirect?
No.
All right, thanks for your testimony. You're excused.
That's all we need.
Why would you just walk away from that? Had no relevance. Yeah, all like the teachers.
Shh. I'd like to call Del Anderson to the stand.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this case under penalty of perjury? Please be seated.
What's your relationship to this case?
I, old man, I'm the neighbor of Sean Wright. I was old. I was the old babysitter of Junior Wright.
Do you have experience babysitting kids?
Yes, I have babysat tons of kids. As captain of the neighborhood patrol team, I've seen tons of troubled kids, but none of them are as troubled as Junior.
How many times have you babysat for the Wright family in the past?
Oh, I babysit Junior and Mark all the time. They're one of my normals.
What behaviors has Junior exhibited?
Well, he's done lots of crazy things. He has destroyed my plants. He has ripped them out of the ground for no reason whatsoever. He has stained my priceless Eldorado car with peanut butter and jelly hands. And he has destroyed countless items while watching over me.
How did Junior get on top of your Eldorado?
No idea. I looked away for 1 second. Next thing you know, he's on top of it.
Does he have a history of climbing things in the past?
Oh yes. He has climbed on top of Myrtle's curio cabinet full of priceless porcelain bingo chips.
And has he broken things in the past?
So, at least 4 bingo chips. And a few items here and there.
And you said, I can't believe it took so long for him to hurt his little self in your witness statement. What did you mean by this?
Well, he climbs on top of so much things. He's such a wild kid. It was just a matter of time before he hurt himself. I'm kind of sad he hurt himself, but just a matter of time.
Thank you. No further questions? Pass the witness.
Mr. Anderson, you seem like you have a lot of bias on this opinion. Have you ever had problems with any other children before?
Yes.
What were they?
According to this case.
I'm sorry, I didn't hear your answer there.
Am I allowed to exhibit the witness statement?
Yes, you are, yes.
This one was mine.
We're way ahead of time, so you've got lots of time.
Okay. All right. So your past cases with other kids, can you mention this?
For the record, you're working with the affidavit of Bill Anderson, is that correct?
That is correct.
Okay, and that's on page 19 of our materials. Go ahead.
All right. So you said you would have had other problems with other children. Can you recite those, please? No. Okay. I don't. Are you positive that you saw Junior and Just Junior in your flowers bed that day? Was it Just Junior? Mark. It was Mark.
It was brother.
Brother. Okay?
And yes, they were trampling on him. Later came back and ripped him right out. As if, trampling wasn't enough.
So you said Mark.
It was his brother.
You said in your witness statements, first Junior would run and play in my flowers when he and the brother were outside. Apparently that was not enough to join my plan. So then he would decided it would be fun to pull him out of the ground. You said that was Mark.
I said his brother.
Mark.
His brother.
Objection. Where is it? Just a second. Argumentative question.
Well, I think the question was directed at who was pulling the flowers out?
Yeah.
Well, isn't he entitled to explore who was pulling the flowers out?
Yeah.
I'm not sure he is, but since you said yes, I'll go with yes. All right, go ahead.
Okay. So who was pulling the flowers out, Mark or Junior?
Junior.
Did they both were involved in it in any way?
Yes, they're both.
Okay. All right. What were your issues with Junior prior to all these situations? Did you have any?
He would get in arguments up and down the street, and he was rude a few of my items.
Okay.
And other people's items.
Did you ever have talks with Miss Wright about her child?
Yes.
What
She did
was it?
seem to care at all. I would mention how she ruined things, or he would ruin things by that, and didn't seem to really care.
And what intention did you approach Miss Wright? How were you acting when you approached her? What were your
I was very calm, as
emotions?
any old person would be.
But you're not being calm in the court of law right now.
Yes, I am.
Okay. How many times did you babysit?
See, now, a skilled lawyer would say to the jury, ladies and gentlemen, you're the triers of the fact, you make your own judgment on that issue.
How many times did you babysit Miss Wright's kids?
A few times.
Okay. Well, you say in your witness statement somewhere that I babysat one time. And all the kids did was run around the next day. So you only babysat one time. In your witness statement, you also say, when you first met with him, I would try to get his attention, but he was always too active in one place. I didn't want to chase him around. Were you just not trying to pay attention to him while you were babysitting him?
Can you rephrase that?
All right. Did you show enough attention to Junior?
Oh, I showed lots of attention as any babysitter.
So you would follow him and like make sure he's doing what he's supposed to be doing, correct?
I would try my best.
And you said he's a cute little kid but small for his age? So you like the kid? Okay. Alright. Did Myrtle talk to other kids? Alright. You said your friend Myrtle babysat her. What were her reactions to after she babysat?
Well, I wouldn't personally know, but when she called me when she got off, she seemed a little hesitant, like a little out of it. She was kind of stressed, I can feel.
Alright. See, Myrtle watched it for, you say Myrtle watched those two for an entire Saturday afternoon and evening. I tried to warn her, said Myrtle, you have no idea what you're in for, just watch out. I babysat one time and all the kids did was run around the next day. They wouldn't even sit in front of the TV. Myrtle called me when they left her place that night. She sounded like she barely had energy to dial the phone. She told me if she had known she was going to be babysitting a little Diana, she would have said no, no matter how big her finger depths were. That is not at all what you just told me. Sure, you can decide if he's a
That's
stressful
exactly what I
witness.
just said.
Thank you.
That's exactly what he just said.
You can redirect. The rules permit it. 4 questions.
I'd like to redirect.
Okay.
So, Myrtle was upset, and like you said before, Myrtle was upset after she was babysitting because of how energetic the kids were, right?
A little stressed out.
And would you say that, so it was Junior that was playing in your plants and ruined them, right?
Yes.
And how many times have you babysat for the Wright family?
Just once.
Okay. Thank you. No further questions.
No, he said just once. Just once.
I'm going to allow it. Go ahead.
You can come back up?
Just one.
Just one. Okay.
Just one.
That's all I need. So before you said you babysat Junior a few times. How many times did you babysit him?
One.
Witnesses excused. All right, we're now at the stage where we have what's called the lawyer's summation. Personally, I consider summation one of the most critical stages of the case because this is counsel's chance. You can assume counsel's had the case a long time and has given a lot of thought, and therefore it's important that we listen to their summations. I ask you to listen especially to their logic and recognize that what lawyers tell you is not evidence, so they're bound by the evidence that was adduced from the witness stand in the course of the trial. But nevertheless, you want to listen to their logic and to their recital of the facts. It's not unusual that a lawyer gets the facts wrong, and I don't believe they do that on purpose. I think it happens as often as not because they're so busy thinking about their next question. Perhaps they're not paying really as close attention as you should be to what the witness actually said. So listen carefully to their arguments. Keep also in mind that they are not the final adjudicator of the law. I will give you the law, and I'm responsible for the law. Their job is to argue the facts and tie the facts into the law. Since the plaintiff has the burden of proof, the plaintiff will go first, and we got that right. That's good. Okay, so the plaintiff should close first.
Ladies and gentlemen of the jury, we would like to thank you for listening to our trial, and we hope that you find Play and Learn Child Center negligent. There are 4 components to being negligent. There was a duty That duty being to watch over Junior properly. There's a breach of that duty when there weren't enough teachers in the room, according to law 315.6. There was a cause, meaning that Junior was definitely injured, and if he was properly supervised, he wouldn't have been injured. And lastly, there was an injury, that being a broken arm and many years of his young life being taken away for therapy and having to get a doctor's visits. Of course, we can't trust the enemy counsel or opposing counsel. They have contradicted themselves as proven with Dell's statement. And Dr. Baldwin, he went against the entire board of doctors, a doctor from Olympii. Of course, that doesn't sound very reasonable. We hope that with our expert statements, our insider info with Lee Morrison, and of course the parent, that you will surely find that Junior does not have HID. He's just a normal kid. He can be bad sometimes. Kids can do that, but he doesn't have HID. And Playing Their Child Center is definitely guilty of negligence. Thank you.
Thank you. Are you ready? Go ahead, please.
Ladies and gentlemen, I would like you to look at the facts. First of all, Dr. Ellis Baldwin he did not spend as much time as he was supposed to with Junior. But their doctor only spent one session with him. He was paid, and he is a medical professional, and he exhibited almost all of the signs of HID. So I believe that he was able to make a correct diagnosis. Also, we can look at the fact that the breach of duty did not cause the injury. They were fully staffed. The Playing Learn Child Care Center was fully staffed on that day, despite of the pink eye outbreak. But what happened is there was an emergency in the next room, so following their procedures, one of the teachers left the room to go help with the emergency in the next room. So they were following their procedures, and there was no breach in duty. As they were talking with Dell Anderson, he made a simple mistake. He just got confused. He babysits a lot of kids, and mistakes happen. Obviously, everyone's human, and they're not going to be perfect. Or like with Sydney Little. It's written down so that she doesn't have to have that memorized, okay? I'm sure that she has that in her office that she can reference to see how much education these workers need. And I'm sure they follow that, but she's just forgotten. She's just human. Thank you.
Thank you, Pam. It's my responsibility at this point to give you the mechanics of how to go about deciding the case. And of course, I do this with juries all the time in criminal and civil cases. So my responsibility is to make sure that you know how to go about deciding the case. Ultimately, of course, it will be your decision to decide the case. And you should dispel from your hearts and your minds any passion or any sympathy or any thought of favor. You represent all the people of Venango County or of District of Columbia, and it is your responsibility to do justice for all the people, on behalf of all the people, to the parties. The parties count on you to do justice for them in this case. The case involves issues of negligence and comparative negligence. And the first question is, did the defendant have a duty to Junior? I don't think there's much dispute that the defendant had a duty to Junior. They were engaged by the father, and of course licensed by the municipality, and therefore they have a duty to run their facility appropriately. Was there a breach of that duty? That's a closer question, which I think you have to take into account what the witnesses told you and what you find to be the credible evidence. And then the other difficult issue, and it's almost always the most difficult issue in negligence cases, and especially say medical negligence cases, that is causation. Did the negligence, which in fact you find occurred, did it in fact bring about the injury? Was it a proximate cause of the injury? Now in this case, as you know, there's a stipulation as to the damages. There are special damages of $115,000, which includes the hospitalization, the medical treatment, physical therapy, and even daycare where Junior's receiving special therapy, lost $5,000 in wages and seeing to her child's needs. Now there's also a claim for pain and suffering. Pain and suffering is allowed in these cases so long as you are satisfied that it exists. And pain and suffering is what the injuries brought about and the extent to which Junior experienced pain and suffering, which is not compensated for in the special damages. The special damages is reimbursed with the payment of the doctors, the hospitals, the physical therapists. But should Junior receive something in the context of that he experienced pain? And the evidence isn't real clear on this, that fractures are generally very painful. Sometimes fractures involve what we call residuals, which means they may last for a long time. We don't have a lot of substantial evidence on whether or not there's a residual injury from the fracture. Kids, especially 3-year-olds, have a bright future in terms of healing. They generally heal better, but nevertheless you might think to also future pain and suffering. Would he perhaps be prevented from playing football or soccer or something because of the injury to his arm? Nevertheless, the plaintiff has asked for pain and suffering. And then we also have the issue then of comparative negligence, and comparative negligence is where you find that the parent in this case was in fact negligent. And the defense theory on that would be that the parent did not disclose the HIV diagnosis from the doctor when the parent enrolled the child at the facility, and the parent did not also disclose the child's issues at the prior facility. And whether or not the parents should have disclosed that in the context of the professional facility using the resources they should have used is an issue that you have to assess. And maybe it wouldn't have made any difference under the facts of this case, maybe it would, that's for you to decide. But nevertheless, the defense theory is that the parent did not disclose information which would have guided their behavior. The burden of proof, as I've said earlier, is by performance of the evidence, and as to the negligence of the defendant, the plaintiff has the burden of proving that, and as to the negligence of the plaintiff, the defendant has the burden of proving the plaintiff's contributory negligence. There are two types of evidence in most trials, and in this trial, perhaps circumstantial evidence is not quite as important as it is in many trials, but it has some bearing. So I'm going to instruct you, first of all, on direct evidence. Direct evidence depends on, and that is what witnesses said they saw and heard themselves, and that depends on the credibility of the witness. Do you believe the witness? Did the witness see what he said he saw and heard, and is that credible? Circumstantial evidence is evidence which points to the existence of other facts which are in question. My best example of circumstantial evidence is I like to take long walks in the woods, and I like to take long walks in the woods when there's fresh snow. And if you're walking in the woods when there's fresh snow, you come to a clearing and you see the tracks of an animal, then you can infer from that, based on that observation, that an animal traversed that location from the time it snowed, after the time it snowed. That's an example of circumstantial evidence. In a lot of ways, circumstantial evidence is just as compelling as direct evidence, and circumstantial evidence is important in this case, so you may also use the circumstantial evidence in the context of who you believe. You have to assess credibility, and I said earlier, and I mean this with emphasis, when you sit as a juror, the hardest part and the most important part of being a juror is assessing credibility. And you are expected to weigh the credibility of the witnesses and compare the credibility of the witnesses and decide which witnesses' testimony should have more weight than others or less weight than others. The concept of bias is very much at work in all trials, and it's very much at work in this trial. Both sides have pointed out an example of bias. The witness who just testified, Ms. Delp, I think it was, testified about being upset with the family and upset with the little boy. That certainly goes to bias. There was testimony that the one doctor, the PhD psychologist, is receiving a substantial amount of money for her testimony. That's another example of bias. Now, whether or not bias drives your decision is for you to decide, because a person can be biased and still be telling the truth. But you still have to recognize that bias is there. The most common example I see is in almost every criminal trial that the mother or the father takes a stand and plaintively talks about their child's innocence, but we all recognize the parents virtually would do anything for their children, and that's a really classic example of bias. And I'm not saying that they would be lying, but it is something when you assess credibility you should take into account. And bias was definitely presented in this case by both sides and is a material factor in your decision. Witnesses have also been known to be mistaken in their observations and are not necessarily lying. They just simply don't accurately remember it. Another aspect of this case which is important is the concept of expert testimony. We had two experts in this case. The expert psychologist, who was, as I recall, is a PhD psychologist, and of course you had the pediatrician, who was a medical doctor. Both of them are experts and both qualified in their field, and significantly they disagreed on important components of the case, which again you will have to assess credibility and decide whether you believe one or the other, or components of the testimony of one or the other. But I would say assessing the credibility of the two experts is an important facet of deciding this case. Now in this case, the plaintiff contends that the facility did not properly care for him. The plaintiff contends that the facility at the time of the event was not staffed according to the regulations, that one of the assistant teachers was out of the room, and that the crackers were left on the changing table and became essentially an attractive nuisance to the 3-year-old, and the 3-year-old crawled up on the table to get the crackers and fell and was hurt. And that is a question of whether or not he was properly supervised, taking into account plaintiff's theory that this was a special needs child and that the facility is responsible, whether it's a special needs child or any child, because 3-year-olds tend to do that. The defense contention is, had they known he was a special needs child with HIV, the teachers would have been much more sensitive to his whereabouts and would have more closely monitored his behavior. So it is for you to decide. Now, as I understand the way this is going to work out, they're each going to be called upon to assess their evaluation. Is that before or after the verdict is announced?
Next before.
Okay, so you will take the time now to clean up your slip, and then I guess we'll start with the students up there. And what I would also ask you to do is make an entry on, not based on individual scores, but based on the information presented. Please check which team you feel presented the strongest case and won this mock trial. Make an entry there and pass your entry down. Do not discuss your ultimate verdict when you make your comments, but you may comment upon what impressed you or didn't impress you. After all, this is an educational exercise. I think it'd probably be fair to start with the teachers because they're professionals rather than start with the students. So what I'm asking then, Mr. Gailey, for instance, in your case, tell them what you like, what you didn't like, and you can be as specific as you want. And then make a finding, but don't announce your finding. Our finding will be for all of us collected.
It's clear that you guys put a lot of time into this and a lot of practice. Most of your work was done without notes or without a net, and that impresses me. Note about Judge White's comments on credibility in the future when you're in situations like this, whether it be a court case, or a job interview, or a speech for a college course. Credibility is key. The best way that you can achieve that is to be direct, to look people in the eye, and speak clearly and loudly. There were a few instances where you guys were kind of quiet, you were mumbling, you weren't looking at people. That doesn't grab people's attention, and it does not make you credible. But when you speak out, when you look at people while you're speaking to them, they will want to believe what you say. So remember that in the future. Take that with you if you take anything from this trial.
Again, just like Mr. Gailey, I think everyone, it was clear to put some time into it. I personally felt I could tell a few of you put more time into it than others. Let me see. I think when you're in a situation like a trial like this, you really, really, really need to listen to what's being said so that you can come back with counter arguments and things like that. Just use some common sense and know your facts, and if you know your facts, you should be able to argue them. And for this, but I think everyone did a good job.
All right, my comment would be circa 2011. I was in that stand with a black dress on as a witness, and I can remember all the hard work that our teams had to put in to do this, how stressful it was. So I want to commend you on, I know this is a process, you had to read all these things, highlight everything, work as a team. So I want to commend you on working together to put this trial on. I thought everybody did a good job.
Well, going forth in line, I'm going to echo everything that was just said. But the one point that stood out that I really wanted to make was you could see who had spent the time and prepared, because when you're reacting on the fly, if you hadn't spent the time preparing, you couldn't react to some of the things that we saw you do today. So you could tell everyone knew what they were doing, but those of you that spent the time knowing parts that maybe weren't even yours, you could tell during the trial that you were able to react a little more effectively, probably.
Yeah, to like piggyback up off of what everybody else has said, just like everybody is presented with the same information. It's just whoever puts in the work and the time, like it knows the little details, prevails.
This was a hard one. You all did good. Like you said, you can tell like who worked really hard and like, the people that like didn't do too well with like what the difference is.
You all did a good job, but some of you need to like have more eye contact, and you all had really well written evidence and reacted to other people's evidence.
Again, everyone did very well, but some people like pointed out some evidence that I thought like made it so it changed my opinion more. And besides that, just like some people were like better speakers than others, and that's about it.
Yeah, I agree with what he said. Some of you are more confident than others, which like means a lot. Makes us believe more when you use confidence and you're loud. Some of you are quiet. Wasn't able to hear like your points very well. But overall, you guys seem pretty prepared and use your facts.
My comments would be, first of all, you benefit from doing this. It's hard work, and when I was your age, I'd have been terrified, frankly, to stand up in front of all these people and have to do this. It would have been frightening to me. So I honor your courage. If nothing else, you did it. You got through it. Nobody got hurt, and you have, I'm certainly acquired knowledge and skills that will be useful to you. to me, trying a case is in a lot of ways like putting on a show. Your job is, you know generally where the case is going to go, and then you will, you know where your case is going to go, and your job then is to recognize the jury's going to decide it, and so you sell your facts to the jury. And so whether you're in a courtroom or a lawyer or simply a salesperson trying to sell a product, the lesson to be learned there is think about it beforehand, analyze how you want to do it in a way that is beneficial to your objective, and then do it. And that's the way you try a case as a lawyer, and it's the way you sell a product. It's probably the way you teach, although I haven't fully thought that through. But so this is all useful experience. I will say the one problem we had is, and it's maybe the way the courtroom was set up. The witness chair was pointed at in that direction. Had I tried this case as a judge, I would have made sure the witness chair was actually looking directly at the jury, because it's important that you talk to the jury and not talk to counsel who is examining you. And I think the persons on the jury noticed, and I strongly agree with them, there was a strong indication of those who were very well prepared based upon how they handled the testimony and the examination versus those who either didn't have the time to prepare or for other reasons. But the preparation was evident in some, and it was, in my opinion, quite impressive, frankly. Now, as I understand at this point, what we're going to do is I'm going to ask the jurors to mark your findings, pass them down, or has that already been done? Is this it? This is it? You've already done it? What does that mean? You weren't paying attention to my remarks? Okay. Okay, so if I'm reading this correctly, I haven't dovetailed my numbers, but I assume my numbers would fit. We have a ruling in favor of the plaintiff, and for what it's worth, I feel strongly the plaintiff should prevail in this case, not necessarily because of the skills of counsel or the outcome of the counsel. This is just a kind of a strong plaintiff's case. A 3-year-old, generally it's hard to find negligence on a 3-year-old, and the 3-year-old was hurt, and the parent entrusted the facility. However, I would have probably attributed some comparative negligence to the parent, because I think the parent had a really specific duty to make sure that they were paying proper attention because of his special needs. So I would have probably found something like 75%, 25%. In other words, 75% of the fault was attributed to the plaintiff, 25% was attributed to the defendant. And we know the damages were $115,000 plus the specials, so it's $165,000. So if you did the math, that would be the way I would have structured the verdict. So it was a strong factual pattern for the plaintiffs, but there was lots of meat there for the defendants to work on, and creating the comparative negligence was an area the defense could work on, and did work on, in my opinion, successfully in this case. Did I present that the way the jurors, it was the ruling of the jurors and the court was that the plaintiff prevailed. But again, I feel very strongly that the facts were a tad biased for the plaintiff. Can we answer any questions from the advocates? I think the first question is, am I going to get an A for this?
I hope so.
No questions?
No.
Are we done?
All right, well, thank you, everybody, for